Hello, everyone. Today we explore the limitations law puts on contract damages by situating the topic in its historical and doctrinal frame. You might imagine a situation where a small value contract, like hiring a mechanic to clean a carburetor, could have high damages, like if shoddy work causes an airplane to fall out of the sky. How far do contract damages go? What are the limits of contractual liability? To answer that question thoughtfully, let's begin with a reminder of the purpose of contract law. The overarching goal of contract law is to put an aggrieved party in a position as good as performance would have done, but no better, because the goal here is economic efficiency. The restatement groups all monetary relief under the heading of judicial remedies and warns that those remedies are subject to three gatekeepers: mitigation, certainty, and, first and foremost, foreseeability. These curb runaway verdicts, and these limits uphold both economic efficiency and the moral intuition that a promisor should answer only for risks he or she had reason to contemplate at the moment of agreement. Hadley versus Baxendale was a case decided by the British Court of Exchequer in 1854. It supplies a classic articulation. A miller's crankshaft broke, the carrier's late delivery forced the mill to set idle, and the miller sued for lost profits. The court denied recovery because the carrier had never been told that delay would halt production. American courts absorbed this wholesale, and Section 351 of the Restatement Second of Contracts now states the rule in modern form. A loss is not recoverable if it was not within the contemplation of both parties as a probable result of breach at the time the contract was made. So, notice the temporal focus. We don't ask what the defendant foresaw on the day of trial. We freeze the frame at contract formation because that's when the risk allocation occurred. The test has two prongs. The first prong covers losses that arise naturally, which are damages any similarly situated plaintiff would suffer. And lawyers sometimes call these direct damages. They're almost always foreseeable because they flow from the ordinary course of events. So the cost to buy a substitute when a supplier fails to deliver is a paradigmatic example. The second prong covers special or consequential damages, which are losses that are particular to the plaintiff's circumstance, and these are recoverable only if the defendant had actual or constructive notice of some special risk. Section 351 also makes explicit what Hadley implied. Knowledge and special risk can come from either the contract's express terms, the surrounding commercial context, or affirmative disclosure by the promisee. A buyer who tells a shipper, "Those widgets must arrive by Friday because my holiday catalog drops on Monday," has preserved a right to claim lost profits if the widgets arrive late. But absent that disclosure, the same claim might flunk the foreseeability screen. Imagine a software as a service vendor who agrees to maintain 99.9% uptime for an e-commerce client during Black Friday weekend. If a 6-hour outage occurs, lost sales are entirely predictable and therefore a foreseeable consequence. The vendor in that case would almost certainly be tagged with that loss, unless the written contract contains an enforceable limitations clause. By contrast, if the client's public relations firm had scheduled a splashy advertising campaign that projected double traffic but never mentioned it, the incremental lost profits flowing from that surge would almost certainly be disallowed under Section 351. A quick word on foreseeability and the Uniform Commercial Code. Article 2 adopts the same conceptual framework as you see in the restatement. Section 27152 allows a buyer to recover consequential damages resulting from the seller's breach, including lost profits, provided that the seller had reason to know of the buyer's requirements and the losses could not be prevented by cover or otherwise. Courts routinely interpret that reason to know language by reference back to Hadley's dual-prong test. So the common law and the UCC are in harmony on this point. Because foreseeability hinges on information available at the outset, transactional lawyers counsel clients to engage in risk pre-clearance. If you are a promisee and a particular breach would trigger risk domino effect harms, disclose those risks up front and document the conversation. If you are the promisor and the other side has not made any disclosures, you might build a contractual cap on consequential damages into the contract itself, or have a bespoke liquidated damages schedule, because that will minimize your risk. Let's walk through a miniature hypo. A winery with a glass supplier for 50,000 custom bottles is scheduled to deliver on June 1st. The supplier is late, forcing the winery to rent temporary storage tanks to hold the finished wine. That rental expense is a direct foreseeable consequence and is likely recoverable. If, however, the winery also loses a lucrative distribution deal in Japan because the shipping window closes, that loss is consequential. Recovery turns on whether the winery told the supplier at contract formation that missing June 1st would torpedo an export order. If the seller knew, the loss passes to Section 351, and if not, it probably fails the foreseeability screen. So remember, disclose special risks or lose them. The foreseeability limitation polices the edge of expectation damages by filtering out surprise losses, and it operates through a two-step inquiry. Ordinary course harms are in, special harms require notice. Restatement 351 and UCC 2715-2 anchor the rule in black letter authority. Operationally, foreseeability incentivizes efficient information exchange during negotiation and aligns liability with consensual risk allocation. And so we see that foreseeability draws a line around which categories of loss the law will recognize. Our next task is to ask a different question. Once a given loss is deemed foreseeable, can the plaintiff actually prove the dollars and cents with enough precision for a court to award them? That evidentiary gateway is called the certainty doctrine, and it's codified in Restatement Section 352. The law will not indulge in errors of arithmetic. If the amount the plaintiff claims is speculative, that claim probably fails. So now that we understand foreseeability, let's discuss the certainty requirement in more detail. Let's unpack the policy behind the certainty rule. I want to show you how two separate inquiries are made by courts. They ask the certainty of the entitlement and the certainty of its amount. And we'll compare how courts treat established businesses versus startups when lost profit damages in particular are at stake. And then I'll close that discussion with some practical advice on building an evidentiary record. So let's start with the policy. Contract law aspires to compensate, not create windfalls. If triers of fact are asked to conjure numbers out of thin air, defendants are over-deterred and plaintiffs are overcompensated, which skews incentives toward opportunistic litigation. The certainty doctrine forces claimants to tether every dollar requested to proof, and in the restatement's phrasing, proof that is reasonably certain. Certainty also operates as an anti-fraud mechanism. Parties know ex ante they have to keep accurate books because a naked assertion of loss won't be enough. So it creates evidence as well. And point two, the inquiry. Step one is the certainty of entitlement. It's whether the defendant's breach, in fact, caused the loss. So this is essentially a but-for causation test. If the link between the defendant's breach and the loss is too conjectural, the inquiry ends there. Step two is the certainty of amount and asks whether the plaintiff can translate the loss to actual dollars. We don't need mathematical perfection, but we need an evidentiary foundation like audited financials, comparable market data, or expert testimony. A quick historical illustration comes from the famous Lefkowitz fur and stole advertisements case. The Minnesota Supreme Court allowed the plaintiff to recover the advertised value of a Le Pen stole, $139.50, because the figure was printed right in the ad, making the amount of the loss objectively ascertainable. But by contrast, the same court barred recovery for the higher-priced fur coats because their value was speculative and uncertain. So expectation damages were denied. This opinion is actually a demonstration of Section 352 in action. Point three, established business ventures versus new ventures. For ongoing enterprises with a track record, lost profit projections often rest on historical sales data adjusted for industry growth rates. Courts generally find such evidence sufficiently certain. especially when supported by expert econometric analysis. Startups face a steep decline because they lack a performance history. Many courts refuse lost profit awards to nascent firms and instead steer them toward reliance damages, which is recovery for out-of-pocket expenditures, putting them back in the place they would have been had the contract never been formed. It can be hard to prove an uncertain future through yardstick evidence, and the showing must be rigorous. Otherwise, we fail the certainty requirement. So how do you, as counsel, satisfy Section 352 regarding certainty? I'll offer 4 best practices. First, maintain contemporaneous financial statements, profit and loss, balance sheets, and cash flow projections. Second, collect third-party market data, industry averages, competitor performance, and benchmark pricing. Third, document causal pathways. For example, in a supply chain contract, keep the purchase orders you had to cancel and the resale contracts you had to walk away from. And fourth, retain qualified experts early. Economists can model demand curves, accountants can normalize earnings, and industry veterans can testify to capacity constraints. When certainty remains doubtful, you shift to theories. Plaintiffs may pursue reliance damages, restitution, or even nominal damages paired with equitable relief. Remember, the goal is compensation, not punishment. Certainty doctrines enforce that boundary and purpose of contract law as a means of ensuring efficient performance. So we see that certainty is the evidentiary twin or counterpart to foreseeability, where foreseeability asks, was the risk within the party's contemplation? Certainty asks, can we count that loss with confidence? The doctrine polices both entitlement and amount. It applies more leniently to established enterprises than to speculative startups, and it rewards meticulous record keeping. So next, we'll examine the role of mitigation, also known as the avoidability doctrine, which limits harms that could have been avoided through substitute arrangements. Again, so far we've treated contract damages as a 2-step dance. First, we asked, was the harm within the party's contemplation? That was foreseeability. Then we asked, can the claimant count the harm with reasonable precision? And that was certainty. So now we're going to add the third question. Could the injured party have sidestepped or avoided that loss altogether? This answer turns on the mitigation doctrine, also called avoidability, which is in Restatement Section 350 and UCC 2712 and 2706. So let's talk about a new hypothetical. Surge Wheels. Surge Wheels is a plucky e-scooter startup, and 2 weeks before Austin's Spring Festival, Voltcell announces it can't deliver the 4,000 lithium batteries it promised. Surge Wheels now stands at a fork in the road. It could fold its arms, let every scooter sit idle, and sue for 10 days of lost ride profits. Or it could scramble to buy comparable batteries from Electromax at a 15% markup, keep the fleet humming, and then only sue for the extra expense. In the case of contract law, the choice is absolutely crystal clear. Even though a plaintiff is never forced to rescue a breacher, Section 350 and corresponding UCC provisions say that any loss the plaintiff could have avoided without undue risk, burden, or humiliation will be subtracted from the final award. In plain English, courts will not pay you to sulk when a practical workaround lays at your feet. So in this case, you have to get the spare batteries. If Surge Wheels does buy the Electromax batteries, the new units cost $15 more a piece, and let's say overnight shipping adds $3,000. You multiply the premium, $15, by 4,000 batteries, and you get $60,000. You add the shipping, and any total incremental cost is $63,000. That would be the entire damages claim. And Voltcell will have no mitigation defense because Surge Wheels actually mitigated. And again, the damages claim here based on the fact that mitigation occurred. But let's reverse the facts. Suppose Surge Wheels folded its arms, refused to buy the substitute batteries. The festival week slips past, and lost ride profits balloon to $450,000 projected. Only then does the company sue. At trial, Voltcell pulls out the Electromax quote, the same batteries, immediate availability, and demonstrates that Surge Wheels could have limited its pain to $63,000. Under Section 350, the judge should slice away the avoidable chunk of the damages. The verdict should shrink from $450,000 $50,000 to the same $63,000 Surge Wheels could have recovered had it acted promptly. And so the message is unmistakable. Spend $1 today to save 10 tomorrow, or the court will pretend you did and dock your recovery. Again, this is promoting an efficient result. Quality does matter, of course, and a classic case is Parker versus 20th Century Fox, the Shirley MacLaine dispute. When the studio canceled her musical, it offered her a very different role in a Western filmed in Australia. The Supreme Court of California held Shirley MacLaine was not required to accept employment of a different or inferior kind. By analogy, Surge Wheels can't be forced to buy bargain basement batteries that risk spontaneous combustion. A substitute must be commercially comparable in quality, safety, and timing. Mitigation is not limited to substitute performance. Sometimes it takes a quieter form, like salvage. Picture that late harvest winery whose glass bottle supplier breached midsummer. The wine has to remain in stainless steel tanks, and the winery normally rents them out each September. Rather than letting those tanks sit empty, the winery leases them to a local cider startup for $12,000. That $12,000 is value the winery avoided losing, so it will be offset against any damages it captured from the glass supplier. Courts reward thrift just as surely as they punish waste. And personal dignity sets the other boundary. A fired chief financial officer is not required to take a cashier's job in the company cafeteria just to keep damages down. That would impose what the courts call undue humiliation. Likewise, a contractor doesn't need to source scaffolding of dubious integrity and take a safety risk because it's cheaper than renting something that was promised if safety would be compromised. Now, who carries the burden of proof? The breaching party does. Voltcell must show two things. First, that a reasonable substitute was truly available, and second, that Surge Wheels failed to unreasonably obtain it, or failed reasonably to obtain it. Without hard evidence like price lists, supplier quotes, and expert testimony, the mitigation defense collapses. And as I mentioned, as a defense, it's the breaching party that has to raise it. If you represent an injured party, documentation is your shield against the defense. Keep the emails showing that you sourced the market, the bids you received, the invoices you paid, and timestamp notes of every phone call. If you defend a breacher, gather the opposite evidence. You want to look at comparable goods that were sitting on the shelf, transportation options that posed no additional risk, and expert opinion that switching vendors would have been just fine and seamless. Good paperwork turns mitigation from fuzzy equity into crisp arithmetic. And again, we're looking for certainty here, so let's crystallize the doctrine with another example. A craft brewer agrees to buy 500 bags of specialty malt at $2 each, delivery June 1st. On May 20th, the supplier bails. Identical malt is available on the open market for $2.20 a bag. The brewer declines to purchase the replacement grain, and production stops, so they can't profit from any sales of beer. The taproom loses $25,000 in sales. A court should tell the brewer, you could have spent $100, the 20-cent premium times 500 bags, and avoided the entire $25,000 loss. We will award you $100 and nothing more. So the moral of the story is you should spend $100 to save you and your breaching counterparty $25,000. That's the mitigation doctrine distilled to its essence. So where do we stand with limits on damages? Foreseeability polices surprise, certainty polices speculation, and mitigation polices waste. Together, they funnel the sprawling universe of potential harms into a narrow, evidence-based, economically sensible judgment regime for money damages. To close out this conversation on limitation on money damages, let's recall that we have followed damages through three filtering gates: foreseeability, certainty, and mitigation. One guard remains, and this time the parties, not the court, put him on duty. I'm speaking of a liquidated damages clause. A liquidated damages clause is a contractual preset that says if either of us breaches, the payout will be exactly X. Let's start with a crisp definition. Liquidated damages are damages that the parties establish in the contract as the remedy in case a breach occurs later. Think earnest money deposits in real estate or per day late fees in construction contracts, or fixed buyout sums in athlete free agency clauses. These are established in the contract itself, but courts won't rubber stamp every prefabricated number. For more than a century, judges have refused to enforce a clause that looks less like a genuine pre-estimate of harm and more like a cudgel designed to compel performance. The restatement calls such clauses penalties. To separate valid forecasts from penalties, courts apply a two-prong reasonableness test to whether liquidated damages clauses are enforceable. First, uncertainty of formation. Were the parties confronting damages difficult or impossible to estimate when they signed? And second, reasonableness of the forecast. Is the number chosen a rough proxy for the anticipated, or in some jurisdictions, the actual loss? If the answer to both questions is yes, then the liquidated damage clause stands. If the answer to either is no, the clause generally fails, and the plaintiff must prove traditional expectation damages instead. This framework appears in both the Restatement Section 356 and the Uniform Commercial Code Section 2718.1, the latter adding that a special consumer goods rider against unreasonably large sums is unenforceable. A quick illustration is, just before hurricane season, Gulfport Marina hires bay pile divers to reinforce seawall pilings for $4 million. And they agree to a liquidated figure of $80,000 per day for every day of delay. At signing, the parties know a storm surge could destroy boats worth tens of millions, but the exact total of damage is unknowable. Uncertainty is satisfied here. Historical data show that an unreinforced wall fails roughly once every 10 years, producing average daily losses of $75,000 to $90,000. The $80,000 price tag looks like a reasonable forecast in this case, so the clause should survive judicial scrutiny. Contrast that with a $500,000 per day figure. Although the boats are worth $10 million, a court would likely strike that as a penalty because it overshoots every plausible loss scenario on a probabilistic basis. Timing matters. Most states ask whether the clause was reasonable when it was made. A minority of courts, including California, also let courts consider the actual loss when breach occurs. That distinction can flip outcomes. So be sure to cite the governing jurisdiction on any exam or in practice, because here there are significant differences between different states. So how do liquidated damages interact with our earlier doctrines on limitation? Foreseeability. A valid liquidated damages amount is by definition within the party's contemplation. They actually contemplated it. So Hadley disputes rarely arise once the clause passes the penalty test. How about certainty? The clause replaces after the fact proof with an ex ante proxy, which is why the uncertainty prong is so important when deciding whether or not it's valid. And how about mitigation? This is an elegant twist. If the contract sets a fixed payout, the plaintiff may collect it even after declining to cover, unless the clause itself demands mitigation. Courts treat the liquidated number as the entire bargain on damages, including the bargain on how much effort one has to take to mitigate. Time to weave our running story together. So we'll go back to Lake Harvest Winery for a grand finale. Imagine the winery's June 1st bottle contract included the clause: if seller delivers later than June 1st, seller shall pay buyer $25,000 as liquidated damages, plus freight differential, if buyer sources replacement bottles. On May 28th, seller emails and says, we'll be 1 week late. The winery's lawyer now walks through all four doctrines in sequence. So let's do that as well. Starting with foreseeability, a June miss means fermentation tanks stay full, export windows close, and cash flow tightens. Those risks were spelled out in the negotiating term sheet, and they're well understood in the industry, so they are clearly contemplated. How about certainty? Instead of projecting lost Japanese profits with spreadsheets, the winery points to the contractual numbers, 25,000. Baked into this number is evidence that there was background behind the value of these bottles. The evidentiary headache basically evaporates. Mitigation is also served because the clause's second half allows recovery only for actual freight premiums. That nudges the winery to cover quickly, aligning incentives with Section 350. And how about whether this clause is valid? Well, at formation, both sides know that late season switching costs roughly, let's say, $18,000 to $30,000. So if $25,000 is right down the middle of what could have cost. That precise figure being unknowable in advance, the clause should therefore be enforced, letting the winery collect basically the $25,000 and any documented freight differential. Again, it's probably smart to put that freight differential in the contract because we want to incentivize cover. Flip one fact, however, and see the gears jam. Suppose the clause had said seller shall pay buyer $200,000 per day of delay. That is 4 times the entire contract price for the bottles. A court would almost certainly brand it as a penalty, strike it down, and force the winery back into traditional Hadley, Baxendale, and certainty analysis type damages calculation. So before we close, I'll offer 2 practical drafting tips that come out of this. First is anchor your liquidated damages number to data, historical variances, industry benchmarks, or probabilistic models. You might even include the basis in the recitals. Judges will read them. And pair the clause with a cap on consequential damages. If the clause is ever struck, the cap still guards against runaway verdicts. So if you're the seller, you want to make sure that we do have that damages cap, even if you have a liquidated damages clause, because it may fail. Liquidated damages are a private attempt to swap courtroom uncertainty for upfront predictability. Courts bless the swap only where damages were hard to measure and the chosen figure is reasonable. Once validated, the court will preempt most foreseeability, certainty, and mitigation fights, giving the parties the commercial certainty they generally want and what they clearly bargained for when they wrote those liquidated damage clauses. And that wraps up our conversation on limitations in money damages. We've mapped the entire route from breach to dollars, how to foresee loss, how to prove it with confidence, and how to avoid it when you can. And if you plan ahead, you can pre-price whatever risk remains. Thank you for joining me on this exploration of contract remedies and their limitations.